Sam Bankman-Fried pulled back one new trial motion, but his appeal fight is not over. The tension is withdrawing the Rule 33 request does not end the broader challenge to his conviction and sentence. The confirmed baseline is Bankman-Fried is serving a 25-year sentence and withdrew a federal motion for a new trial without prejudice. That makes this less about one withdrawn motion and more about appeal path. The anchor number is 25 years, while Rule 33 shows the scale already visible. That keeps the opening question tight. Can SBF move past appeal ruling without the story outrunning its evidence? A viewer who only sees one withdrawn motion misses why SDNY filing and Second Circuit define the risk range. The baseline matters because the filing followed questions about whether he received help with a Pro Se request connected to a Rule 33 motion. This gives viewers the frame before reacting to the headline. The useful split is what is already visible versus what still needs confirmation. Without that frame, SBF can look simpler than it is. The second marker is SDNY filing, because that is where the story starts to become measurable. If that point is ignored, the headline can sound stronger than the confirmed facts allow. That baseline also explains why Second Circuit belongs in the setup rather than the conclusion. Most people arrive after the move is obvious and the easy upside is gone. We focus on serious crypto education and high-quality signals before the crowd rushes in, so you can understand the setup earlier and move sooner. If you want that edge, visit the link below now. The mechanism is straightforward. Withdrawing without prejudice preserves the possibility of renewing the request after appeal and reassignment issues are addressed. That mechanism changes how risk is read because the next move depends on structure, not emotion. For SBF, the stress point is appeal path, and the practical signal is appeal ruling. In plain English, viewers should ask whether the process behind the event is actually working. A headline can attract attention, but the mechanism decides whether the attention creates a durable change. The mechanism ties 25 years to SDNY filing, so the next reaction is not random. The affected side is FTX, and anyone using the story as a risk signal. FTX creditors and crypto observers get no immediate reset. The active lane remains the Second Circuit appeal and judge reassignment request. That consequence matters because it can change behavior before a final outcome is known. The immediate read is tied to Rule 33, not broad market talk. The scope should stay narrow. The story reaches the people, protocols, traders, or institutions closest to appeal path. It does not automatically prove a wider market outcome. Appeal also matters here because it shapes the route from appeal path to actual decisions. The open question is narrow. No court ruling has granted a new trial or reassigned the case. The appeal outcome remains unresolved. This is where speculation has to stop. A claim is useful only if it connects to appeal ruling or another confirmed signal. Until then, the story is a pressure test, not a settled result. The unresolved side matters because it prevents viewers from treating a setup as a guarantee. The better read is to keep the confirmed facts separate from the missing proof. The proof has to appear in appeal ruling, not just in repeated claims about SBF. Most people arrive after the move is obvious and the easy upside is gone. We focus on serious crypto education and high-quality signals before the crowd rushes in, so you can understand the setup earlier and move sooner. If you want that edge, visit the link below now. For Sam Bankman, the next signal is a court decision on the direct appeal or the request to move the matter away from Judge Kaplan. That is the point where the story moves from setup to confirmation. If that signal fails, the safer read is that appeal path has not held. If it arrives, SBF gets a clearer path forward. The close is practical. Remember appeal ruling, compare it with Second Circuit, and judge the next move only when the evidence changes. That is why the final read stays tied to SDNY filing, Second Circuit, and appeal ruling.